The law of occupation is a branch of international humanitarian law (HL), which is part of the laws of war. It sets out the legal rules that govern the relationship between a military force occupying a territory, the occupying power, and the civilian population and authorities of the occupied territory. Where does it come from? Its main sources are 1. The 1907 Hague Regulations, especially the Hague Convention IV and its annexed regulations concerning the laws and customs of war on land, to the Fourth Geneva Convention of 1949, which focuses on the protection of civilians during armed conflicts. 3. Customary international law, meaning general practices accepted as law by the international community. What is its core principle? The law treats occupation as a temporary situation. It does not grant sovereignty over the territory to the occupier. It imposes obligations on the occupying power, including respect and protect the lives, property, and dignity of the local population, maintain, as far as possible, the existing laws and institutions, unless absolutely prevented, prohibit the transfer of the occupier's own population into the occupied territory and the forced displacement of the local people. Such acts can be war crimes. Provide for the basic needs of the civilian population, such as food, medical care, and public order. What is its purpose? Its main goal is to protect civilians and to prevent the occupier from exploiting or annexing the territory permanently under the cover of military occupation. Examples: the Israeli occupation of Palestinian territories is one of the most discussed and monitored examples under the law of occupation. The U.S. occupation of Iraq after 2003 was also governed by these legal rules. If you'd like, I can share specific articles from the Hague Regulations or Geneva